RFNG is supported in part by funding from the Social Sciences and Humanities Research Council. Section 35, the most notable piece of legislation in Canadian history in relation to Indigenous peoples across the country. It says, the existing Aboriginal and Treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. That one sentence outlines Canada's legal requirement to protect inherent rights. The Canadian Constitution is one strong anchor for Aboriginal rights in Canada. Now, we also have the United Nations Declaration on the Rights of Indigenous Peoples, also called UNDRIP. UNDRIP was declared in 2007, but it took 14 years for Canada to officially adopt it. In 2021, the federal government passed the United Nations Declaration on the Rights of Indigenous Peoples Act. It recognizes UNDRIP as an international human rights instrument that can help interpret and apply Canadian law. How are our inherent rights really protected? Kinawea, and welcome to Inherent Rights and Foreign Voices, a podcast brought to you by the Centre for First Nations Governance and the Rebuilding First Nations Governance Project. Today, we're delving into Canada's legal orders to see why this section of the Constitution is so important to Indigenous peoples and what it means for our rights and governance. Julie Williams Indishnakas, Minjikining Indonjaba, Gigon Dodim Anishinaabe Kweyandao. My name is Julie Williams, and I'm a Ojibwe from Rama First Nation, and today I will be your host. Through my work as a strategic policy advisor, I have helped conduct research on policy and governance, including for the Rebuilding First Nations Governance Project. My years examining First Nations constitution building, Section 35, and inherent rights, the Indian Act, policy, and law have informed the way I help communities think about reclaiming and rebuilding their own forms of government. Achieving self-government is hard, multi-generational work. Aboriginal and treaty rights, including the right to self-government, were constitutionally recognized more than 40 years ago. Progress in law has been made and some self-government agreements have been reached, but most First Nations in Canada are still governing under the Indian Act and not implementing their inherent rights. Here to begin our conversation on Aboriginal rights is Naomi Metallic. Hailing from the Listigush Mi'kmaq First Nation, Naomi is an assistant professor at the Schulich School of Law at Dalhousie University, where she is the Chancellor's Chair in Aboriginal Law and Policy.
UNDRIP is a fundamental human rights instrument that sets out the minimum standards for the well-being of Indigenous peoples across the world.
Naomi is particularly interested in human rights advocacy and looks to revitalize Indigenous governance through legal, cultural, and economic institutions.
The revitalization of our laws and ways of thinking to support our self-government is some of the most important and rewarding work that we can do, and it brings with it relearning our stories and working with our language, and so there's so much healing that can come with it as well.
Which is perfect, because today she is here to break down Section 35 of the Constitution and tell us exactly how legislation can bring about reconciliation. Happy to have you on the podcast, and I'll invite you to introduce yourself to our listeners and to me, because this is our first time meeting as well.
Gwe walalin in Deluizi Naomi Metallic ach Delewi Listiguch Deluizi Banach Nucha Manny Metallic Och and Kitch Madeline Morissette ach Wajigum Kik Melissa ach Jessica. So just a little bit about my family, and my late dad was Emmanuel Metallic, Manny Metallic, and he was from the Listiguch Mi'kmaq First Nation. That's my First Nation, and I also introduced my mom and my sisters in that little introduction. And I am a Mi'kmaq lawyer. I live in Halifax, although I'm from Listiguch, which is in the territory of Mi'kmaqi called Geskebewagi, but I live in territory Eskigawagik or Ekchibuktuk, which is it's called either sometimes, but where Halifax is located. I've been a lawyer and a law professor here for a long time now. I think it's going something on like 25 years. It's getting up there. And I am pleased to be on this podcast with you, Julie.
I have to tell you, I'm super excited to have you here today. There's a lot of practical questions associated with Indigenous rights. And this is not content that is taught in K to 12. So many of us who have a basic understanding have sought this information and our own education. So I'm excited to have this podcast opportunity to actually ask some of these questions because I think there's a great space for us to discuss and to open up knowledge, learning, educational opportunities for anybody who's tuning in. We can start with, the fundamentals. The Constitution recognizes existing Aboriginal and treaty rights in Canada. And I think a lot of people know that, but what does that actually mean in practice, in our daily lives, but also for our First Nations, for our communities? I'm curious to know how you would open that up.
Well, I think it's a work in progress, right? So here we are. There was this, provision put in the Canadian Constitution back in 1982, and there's other parts of it, but the most relevant part says that the Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. And it's really interesting. I just a couple weeks ago taught the history of this to my students in my Aboriginal law class. And Aboriginal law, we call it Canadian law as it relates to Indigenous peoples. There's Indigenous law, which is different. Those are actually the laws of Indigenous folks. But, the Section 35 is part of Aboriginal law. It's a constitutional provision. And it it came as a result of Indigenous peoples pushing and advocacy and having our rights recognized, our inherent ancestral rights recognized in the courts before 1982, but then at 1982, when the government wanted to repatriate the Constitution and create this new document that would recognize fundamental human rights, there's the Charter of Rights and Freedoms that is part of this. We were not really a part of that thinking at the time. The initial proposal just had something like, something to be included in the Charter that said something like Aboriginal rights are not affected by the Charter, will not be abrogated or derogated, but no specific recognition of that right was included. And there were concerns that Canada was going to try to backtrack on the obligations that it had inherited from the British through treaties and the Royal Proclamation and various other things in our country's past. And so it was a fight. That fight went to England. There was folks who wanted to stop patriation because they wanted the UK courts to tell Canada they couldn't do that because they were worried they were going to try to walk away from their obligations. Anyway, sort of the long story short of that is that we get Section 35(1), although there was even debate about it. At one point it got put in, then it got taken out because the provinces had a problem with it. And Indigenous folks were also like, well, but what does this mean? And they were promised future constitutional conversations. They were told, just wait, we'll put this in now, and then we'll figure out what the rest means through these various constitutional conferences that are going to happen in the next 10 years or so. Well, they were supposed to actually even happen between 1 year, but they kind of spanned a little about 10 years, but nothing at the end of the day. There was no, there's various things I could talk about, but because we don't have forever, I will just say that there was no effective amendments of the Constitution, so those rights never got spelled out. And so it kind of left what some people called a box, right? What's in the box? What's in the Section 35 box is what people would ask. And it then fell to the courts to interpret what that means, what Section 30, what an Aboriginal right is, what does it mean? Does it mean the government cannot impact on these rights at all? Does it mean the government can in certain circumstances? So those are all the things that it kind of fell in the court's lap to figure out. And the sort of key cases, one of them came in 1990, the R versus Sparrow decision. That was a big one that started to flesh out what Aboriginal rights meant. And then there was another big one in 1996 called Vanderpeet, which kind of identify what the purpose of Section 35 was supposed to be about, and also what an Aboriginal right is. And without getting into the details in all of them, they were advances. Like the ultimate thing is that these Aboriginal and treaty rights exist. They're recognized that they're not created by Section 35. They are inherent rights. However, the fact that they're recognized means that there are limits on what governments can do in terms of impacting on these rights. So there's a sort of a test that was developed that says that governments have to do something like justifiably infringe. Like if they want to put limitations on these rights, they have to make a case for why they can, and sometimes they won't be able to. And so I guess with that, all I'll say is, without getting into all the details, it's a work in progress. Back to my first point. It's the test that we've been using, and from that we've also drawn the duty to consult, and sort of there's been recognition, and it's included Aboriginal title over the years. But today, now that we have the UN Declaration on the Rights of Indigenous Peoples, we're actually at a moment where we're looking back at that case law and saying, it's probably not good enough, right? In terms of comparing it to what's in UNDRIP, and UNDRIP says these are the minimal fundamental human rights that Indigenous peoples are entitled to across the world. And so as we look back at these tests, there's ways that they don't really line up as they should with UNDRIP. And so there's work happening right now in cases before the courts where people are arguing that we need to shift those tests from the 90s up to today to make them really reflect UNDRIP. So that's what I mean, that they're a sort of a work in progress. But it's exciting. Nothing is like ever sort of like written in stone, right? Everything evolves, and I think evolving in good and progressive ways.
Thank you. So jumping in and shifting a little bit and talking about the United Nations Declaration on the Rights of Indigenous Peoples, which Canada has developed an act around. What I think I've heard you say here is that creates a different threshold in the legal system of Canada, that those court cases from the 90s are sort of below that threshold. And so could you speak a little bit more about what the impact is of the UN Declaration on the Canadian legal framework as it relates to Indigenous peoples? Like, is it more powerful than the Constitution? Like, how do we use it in practice to affirm our rights?
So this also is a work in progress. So I don't have definitive answers because some of this is developing before the courts in real time. But let me say a few things. So first of all, even before the legislation, it is the case when interpreting constitutional law and other Canadian laws that the courts draw on international human rights law. So when they've been interpreting the Charter of Rights and Freedoms, they've gone to international human rights law, like the UN Declaration on the Rights of People, and like the convention, the sort of the main conventions on human rights. And UNDRIP is part of that family of human rights, right? So it is most definitely part of it. It was, recognized, by the UN General Assembly. Many countries voted in favor. Even those who maybe at first didn't endorse it have since, including Canada. So it already applies in that way. But the legislation that Canada passed strengthens its hold within Canadian domestic law. In a couple of different ways. One, it commits Canada to looking at its own laws and updating them, bringing them in line with. So Canadian statutes, for example, should be all examined and looked at to be consistent. So then that's one form of law. Another form of law is constitutional law, right, which is kind of above statute law, and it's typically law, though, that isn't sort of set out in the same way that statute law is. Like statute law is usually very descriptive and specific, right? Like it says you shall not do X or Y or something like that, like a very specific example. Whereas often constitutional law, including our Section 35 with this sort of, I'll go back to my, the box. What's in the box? The box can grow or the box can shrink. I think the box kind of started off kind of shrunken, but it can grow and we can interpret it. So the courts could always, I think, interpret UNDRIP through Section 35 through UNDRIP. But in some ways, the legislation has sort of strengthened the UNDRIP legislation passed by Canada has strengthened that. It speaks to UNDRIP being used to interpret Section 35. There's also other ways. So using UNDRIP to interpret Section 35, I think, is a very important development in our law. And in a couple of recent cases in 2024, our Supreme Court of Canada has said that the effect of the UNDRIP legislation has been to make UNDRIP part of positive Canadian law. And at the very least, I think this means that we have to interpret UNDRIP, our law, Canadian law, including the Constitution, consistent with UNDRIP. And so we're starting to see that. And there's been some cases where the courts are doing that, right? And even there's a few that are going to courts of appeal. So it's very exciting. There's been a decision around FPIC that went to the Court of Appeal last week, I think, a federal court of appeal. There's a case, redefining what is an Aboriginal right that is working its way up to the Supreme Court. So that's really great. There are other arguments that exist, So let me just finish by saying, I think interpretation of UNDRIP, Section 35 using UNDRIP is definitely a possibility. But there's other arguments that people are making now about the UNDRIP legislation and how it can apply perhaps in even stronger ways, right? Like there's a debate about some people saying like it applies almost like a statute. So there's some arguments out there around that. I'm not going to dive into them because I actually even just think that using UNDRIP as an interpretive guide to Section 35 does a lot of work. Because I think when the court started interpreting Section 35, they really didn't know what they were doing. Like they had nothing, they had very little to go with. Let's say they looked to a few other countries or whatever, and they were, for lack of a better way of describing it, like I think they were kind of flying by the seat of their pants in some respects, and they were informed by their own worldviews, right? The liberalism, they kind of felt that Aboriginal rights were in tension with other fundamentally protected rights, and they were sort of like, oh, we're going to take a narrower approach. But that has not borne the test of time. UNDRIP says these are fundamental, universal human rights like all these other rights, and they deserve equal protection. And UNDRIP is very much a document about equality. So I think that that's all going to push against our judges today in interpreting 35 in a much broader, more robust way than in the past 30 years.
I think this is the most optimistic that I've felt, about the future of Indigenous rights in like Canadian legal frameworks. And I think you kind of touched on this a little bit, but it sounds to me like we're really talking about within the Canadian legal system, legislative reconciliation, which is not something I wouldn't say that I fully understand. And I think a lot of us are trying to understand what this means. And even in the context of reconciliation, I think people think of that in terms of like apologizing and moving forward, but not really realizing that there's legal basis for change going forward. Can you tell us a little bit about what legislative reconciliation is and why it's important?
Sure. So let me just start first with another concept, which is constitutionalism. So constitutionalism is this idea that not only do you have a constitution, you live that constitution, meaning lawmakers, governments actually live and breathe and follow it. Like they not only like are forced to, follow something because a court tells them to. No, they do it because they believe in it and they wanna follow the Constitution. Like so an example we might give is the recognition of same-sex marriage in Canada back in the early 2000s, where this was a law. It wasn't. I mean, there were some lower court cases that it held that. It didn't get up to the Supreme Court of Canada, but lawmakers had tried to make the law consistent, recognizing same-sex marriage rights. And so it's this idea that like we have different actors who are involved in this process of recognition and respect of Indigenous peoples' rights. There's Indigenous peoples, there's academics like me, there's lawyers, there's the courts, and there's governments, right? There's the lawmakers, the actual parliament and legislatures, and then you also have like the governments, like the prime minister and cabinet. And so for a long time, a lot of the governments were leaving a lot of the work to the courts, right? And sometimes that did push things forward, and then people would go back to the negotiation table. So the courts are sort of a necessary part of all this, but I think for a long time governments were only, when it came to Aboriginal rights especially, they're just like, no, we're just going to leave it to the courts. We haven't seen as much, I think, sort of active respect and promotion of Aboriginal rights from governments, whether those be executive, I would say, or like legislatures. Like legislatures, that's their main job, is to pass laws. And there were so few laws that have been passed over the past 30, 40 years that really were about the promotion and protection of Aboriginal rights. So the term legislative reconciliation came up in the C-92 reference. The C-92 bill, as most people know, was one of the first statutes that was ever passed in Canada by the federal government that recognized inherent rights. It recognized the inherent right to self-government, including with respect to child and family services, and set out a framework for, Indigenous governments taking control over child and family services. And so, it was in a paper that I wrote, I kind of coined that as legislative reconciliation, because the government of Quebec had fought the federal government doing this. They said they were not allowed to under their constitution. They're not allowed to. But the Supreme Court rejected that and said, of course they're able to do that. We want governments to do the right thing. We want them to follow the constitution and respect Aboriginal rights. So legislative reconciliation is actually, Canadian lawmakers and provinces too can do this, is actually passing laws to recognize and promote and protect Aboriginal rights. Not the opposite, not infringe and harm and deny, but just the opposite. Create frameworks and ways to, make it very obvious that it's expected that, the laws will follow and recognize Aboriginal rights. So that's what legislative reconciliation is. We've seen a few more examples of it, but there could be a lot more that could be happening on that front. So that's when governments sort of move forward with passing laws to recognize and respect Aboriginal rights. UNDRIP puts a big emphasis on that too. I think I forget what article it is, but it speaks to that, I think it's 38. Yeah, states in consultation and cooperation with Indigenous peoples shall take the appropriate measures, including legislative measures, to achieve the ends of the declaration. So you've got that, but we also still have the work of the courts, right? So when the governments don't do what they're supposed to, or when you think they're violating UNDRIP or Section 35, or 35 read through UNDRIP, then we can still go to the courts as well. So it's always going to be like off to one and then to the other, and then negotiation as well. But I think they're all really important, and I hope that the impact of UNDRIP is that more actors within Canada recognize their obligations to respect and promote our rights, the full breadth of rights that is in UNDRIP.
And you touched on self-government there and talking about C-92 and the inherent right to self-govern in area of child welfare. But let's open it up and think about self-government more broadly. What do Section 35 and UNDRIP, what does the right to self-government mean within this context?
Absolutely. So let's just first start, though, with the fact that, like, of all the areas of Aboriginal rights, this has been the one that is the least developed in front of the courts. The courts have been very shy about it. And in fact, and there's a decision from 1996 called Pamajawan, where the Supreme Court adopted the same approach to proving and showing self-government rights as it did to all other Aboriginal rights. Now, its test for all Aboriginal rights comes from Vanderpeet, and it is criticized, significantly criticized, for freezing our rights in the past and for narrowing them down pretty much to hunting and fishing. And the test, so they said you got to pass the same test. It requires showing that, a practice from pre-contact was integral to the group, so integral that it made them who they were. And if you can prove that, then you have the right, and you're exercising that right today, you can exercise that right. But that's incredibly hard to prove on any basis, and it's very, very difficult to prove with respect to self-government because we're evolving peoples as well, and and we're not stuck to 400, 500 years ago. In the case of the East out here in Mi'kma'ki, I mean, our contact with the Europeans was like the 15th century, right? So that's been a real problem in Canada, and I think part of things happening around child welfare and cases around human rights violations around child welfare. All of that kind of led to the legislation that we got from Canada, Bill C-92. But it's only one little sliver of that. We haven't had a much broader recognition of the inherent right to self-government. Well, it's actually in the bill. The bill does, beyond talking about child welfare, does actually recognize a broader right to self-government. And I think that's important too, but I'll park that. Even beyond that, I think I'm writing my PhD right now, right on this question. It's all about how UNDRIP can be a framework for reconciliation with respect to the right to self-government. And I think that is so necessary in Canada for us to move forward. And I spend a lot of time unpacking what led to UNDRIP. What is UNDRIP about? What is it trying to do? What is the spirit behind it? And the spirit behind UNDRIP, the main thing, is the right to self-determination. It is the heart of that of UNDRIP. It's about recognizing Indigenous peoples' right to control their own destinies, and the right to self-determination includes the right to self-government. It's Article 4 that speaks to the right to self-government over local and internal affairs. And self-determination also includes the right to participate in any decisions within the broader state that impact on Indigenous peoples. But I'm just going to hive off self-government for a sec. And there's all kinds of other articles in UNDRIP that build on and inform us about what does 4 mean about a right to autonomy or self-government over local and internal affairs. And I think it's incredibly broad. And I just think it's, the Supreme Court now, the more recent Supreme Court in the last couple years, has been dancing around self-government. And they're sort of saying, we're going to get there soon, and we're going to decide that it's broader than what it was in the past. But they're still not exactly there yet. But they've had a bunch of decisions recently where they've recognized that self-government is happening already in Canada with, modern treaties, and even some forms of self-administered agreements, or the kind of things happening in communities are still maybe not full exercise of self-government, but still some forms of exercise of self-government. And they've been trying to ensure that the governments can't backtrack on stuff like that. So there's some recent cases involving the Honor of the Crown where the court has said some really good things about what governments can't do. So that's all to say, sorry for rambling a bit, but that's all to say that I think UNDRIP is really at its heart is about moving us forward on self-determination and self-government. And, my optimism for where UNDRIP is taking us, I think self-government is really at the heart of that. And I think UNDRIP provides us so many answers around how it can look like, how it will be exercised, when it can be exercised, by whom. Those are all the kind of questions I'm unpacking in my dissertation. And I think all the answers are there. I think that's been another big problem this whole time, is that the government of Canada would prefer to negotiate group by group, issue by issue, and it's taking forever, and it's really preventing us from thriving, and really in some respects, and some important respects, and so I think that we have the right to unilaterally exercise self-government in the areas that UNDRIP touches on, and I think that's fairly broad, and there are ways to work it through and think about it, but I think it's just key to really living the spirit of UNDRIP.
That was really inspiring. I think my understanding previous to this conversation of, the inherent right to self-government is that it exists, but there's this chasm of understanding, how do we actually do it? How do we actually get there? And this is something that I hope for my community. If not for my son, in my lifetime, it would be beautiful. I've done a lot of research and understanding what our traditional forms of self-government were, because in order to revitalize and rebuild self-government in a modern context, we will be much more successful if we understand what it was that our ancestors left for us. And, in Ojibwe territory, that's the clan system. And, I think a lot about what does it mean to reimagine that in a modern context, and how can we apply that to how we govern ourselves in all these areas of our community, education, social welfare, health, and in all aspects, to really embody and live that self-determination. And I've been so uncertain about how do we as a community actually get to that point. And also, this is part of the reason why I'm excited to do this podcast, is because I think more and more of our people need to understand that there is a legal framework in which to achieve this. There's maybe not a roadmap. Nobody's telling us this is the right way to do it, and nobody can tell us that except ourselves. So when I'm sitting here, I'm in my community, and I'm thinking about what the next 40 years holds, and what am I going to do with that 40 years? What advice would you give me or other people like me who are in their community who really believe and know that we can do this, but we don't necessarily have a legal background, we don't have legal counsel, we just know, and we know inside ourselves that we can achieve self-government because we're already self-determining. This is something Creator gave us. But it's intimidating to think about it within the Constitution and these big legal frameworks, which seem so much bigger than us. What can we do now to start working away at that within our communities to actually achieve this? We're planting the seed of the tree we might not sit under.
Mm-hmm. I think what becomes daunting, and one thing that we should try, I always try to emphasize, is that you don't have to, I don't know if you've ever heard, there's this expression, how do you eat an elephant? And here in Mi'kmaq, how do you eat a whale? Because that's more consistent. But one bite at a time. Right? And so you don't have to think about self-government as it's going to be a flick of the finger and it's all going to happen at once, because that can be super overwhelming. And where do you start and what do you do? And I think that at least the framework that I am seeing in UNDRIP is that you do whatever the community needs right now, right? So you can start with one issue, two issue, or as many issues as you're able, if you want to, but you can just start with one. If one issue is really in your community, the thing that, you can start with one, get that going and go to the second. So I think that in terms of the mechanisms to say, we're giving notice to everybody, hi everyone, that we are going to be taking control over this and we are going to be moving forward on that. I think some of the legal mechanisms for letting other people know and how you do it, I think it's all there. And that's I think the answers for that as they come out will be okay, and we will be able to manage all that. I think the harder work, so that's the sort of recognition piece, right? I think that, there is space, and I think there's the frameworks that are coming out of UNDRIP tell us this can all be done and moving forward, and the space to have that recognition and move forward. But the real work is that sort of related, the whole reason we do recognition work, which is the belief, as you have put it, about we'll be better served by using our own ways of doing things and seeing things evolve to 2025, but still influenced by our ways, Anishinaabe ways of seeing things, or Mi'kmaq ways of seeing things, depending on that. And it's this amazing work that is now happening and so there's two tracks. There's two things happening, and they're absolutely like kind of like tied together. But the work of reviving our stories, reviving our laws in our language, reviving the laws in our stories in our land, and doing the work to identify those laws, and then develop those laws in ways that we want to use them today. I mean, today we may want to write down more laws than we did in the past, but we may not. We may want to still keep some oral, but there's work to be done, and work that is happening of identifying what those laws are, based in work on our stories and our language and our material culture and all kinds of, and working with the land. So there's work to be done, and there is academics working with communities to sort of do this work, right? And bringing folks together. Like, one thing I do, I have a group that we're just working with Glooscap stories. Glooscap is like our kind of our hero figure. He's a bit of a trickster at times, more of a bit of a hero figure, but working with his stories and actually getting together with a group of knowledge holders and speakers and actually saying, like, this is what these stories mean, right? This is what it teaches about who we are as Mi'kmaq. And so there's work like that happening, and we then even take that and sort of try to develop it and sort of identify the principles and try to like say them in our language. And then we can use that stuff, right, to then influence the development of whether we want to write a written law, or if we want to have a set of principles that decision makers in our communities can use to problem solve and make decisions. Like, those are the kind of really cool things that can be happening in communities, bringing our knowledge holders together and our speakers and sort of doing that work. And then maybe, working with folks who are more the lawyers or the technicians to bring the space that is happening in the or the recognition work, and saying, okay, we can take this beautiful knowledge, this revitalized knowledge, and bring it into over here, and then start to assert jurisdiction in these areas. So that's how I see the two going together. And like, you can't just do the recognition work and not do the revitalization work, because what are we doing it for if we're not doing it to revitalize who we are, right? Or otherwise we're just like, there's no soul in it, really, right? And who, like, it'll just be potentially adopting laws that really don't fit us, right? So we really want to make sure there's that cultural fit and match. So anyway, so I think it's just so key to do those two types of works, and everyone can do a little bit of part in that, right? It's not just lawyers, right? It's our language speakers, our language holders, our educated folks who have gone out and have come back to the community and really want to help move this forward. There's a role for everybody.
And I think you've just made it accessible to everybody listening to us right now, right? You don't have to be a lawyer. And I think previous to this conversation, I understood the role of sacred stories and how legal scholars have interpreted them to sort of revitalize Indigenous approaches to Indigenous legal orders. I think I had a limited idea of what that could look like in terms of, sacred stories, but also, we have wampum in this territory, and, those are also sacred laws. But it's more than that also. In our territory here, we have Nanabush, who is the, trickster, semi-godlike figure, and all of his stories are lessons, many different types of lessons. And so, people listening today who maybe feel like it's too much to think about it in terms of like structural legal order, can think about it in terms of the revitalization of storytelling, and sharing those stories, learning those stories is the foundation for how we can move forward with self-government in this context, because the lessons therein will lead to how we rebuild, is what I think I've heard you say today, and is exciting because it makes it accessible to everybody in our community. One thing I want to build on here, and we sort of are getting at it a little bit, is the immense wisdom in Indigenous knowledges. It is abundant, and when you start learning, it is overwhelming. And, I often, when I'm studying, because I'm a historian, when I'm studying those old documents and thinking about how my ancestors were governing at the time, I just think about how brilliant they were. What do you think about Indigenous knowledge and that wisdom and the strength of Indigenous legal orders. What does that have to offer Canada?
So much. But I want to come back to Canada, but there's such a healing in doing this work. It's unbelievable, right? Most of my career was spent on doing again, coming back to this idea of doing two kinds of work. There's the revitalization work, the resurgence work, which is like the absolute key of all of this. But you got to but there's also like the work on recognition, so that there can be the space to do this. And you could maybe not do you could only do the resurgence work, but often because we live around Canada and provinces and all that stuff, you need to do the two. But you know what, so it's been more recently, I'd say now 10 years, that I've been doing this resurgence work. Particularly, my dad was a language guy. He wrote a Mi'kmaq dictionary. I work a lot with his work and stories, and it is so healing, and this is where everyone can come into, even if you're not a knowledge holder, like deeply immersed in people engaging with stories. And this is why in the kind of groups and settings we make sure it's a really diverse group. It's not just knowledge holders and speakers, but diverse in terms of gender, diverse in terms of sexual orientation and age, and bring all kinds of people, because everyone has gifts. That's a major teaching in Mi'kmaq and other Indigenous traditions. And everyone can bring like different interpretations and perspectives on things, and they're just phenomenal. But so they can bring different perspectives, but we come together and we discuss it. And the knowledge, and even how the knowledge was embedded. So we had a knowledge holder all weekend doing a course for my students, and he's very much land-based, and we went to some particular places in Nova Scotia that are just rich in stories about Glooscap, but also like it all ties together also with the geography and even the geology. There's a fault line that runs through that used to be a volcanic fault line, and just like explaining how they all kind of come together. And our Mi'kmaq, our ancestors were in these spaces because like this was some of the hardest natural material, and they were going here to collect materials to make their arrowheads and such. And so this area itself was rich with all these like teachings, and it was a place that we went to. And it's hard for me to describe, but the sense, but it's like that law is everywhere. Like it's in the place, it's in the rocks, it's in the stories about the rocks and how the place was made. And we did that because we didn't write things down, but it's actually like the embodiment of our law in the kind of the world around us. Is such a brilliant way to kind of like once you kind of know about the knowledge embedded in it, if you see a landmark, like we went to a few landmarks that are like in the legends, Glooscap created them because of something happened. And once you kind of know that, you'll never look at that landmark again in the same way. And you know that it's about this story that has this teaching related to it. What a phenomenal way to kind of like mark our whole way we think on the landscape, right? So it just really struck me that like kind of like our laws are everywhere, right? And they don't not just in books. That's the thing about European methods, right? They're only in books, but it is everywhere. So I think it's like, in terms of what this planet is currently facing, we were talking about the drought earlier, climate change, and just the massive greed and inequality that we see, that has really taken hold in North America and in other places. Like, all the teachings that I've been learning is really like, teaches us that you can't take more than you need, and you got to think about everything else around you and other people, but also other beings and trees and the world around us and the waters. And so it is, I think, like, from an ecological standpoint, there's a lot to learn that can be of benefit to Canada in terms of what is happening right now. But I think even beyond that, like just even how we treat each other and like we have so many stories that, and even in our language, that, we look down on greed. We don't think that, you only need to take as much as, to sustain yourself, and you've got to help other people. And, that's kind of not how capitalism really has really worked, right? So, and I can only speak from Mi'kma'ki, but I know that, there's similarities between us and other Indigenous nations and how they see things. But, really, in terms of some of the world's ills right now and where we find ourselves, there's so much in our knowledge systems that it seems to me anyway that these are all teachings that we could use a lot more of right now.
Absolutely. I think you've summed it up really perfectly. Not only talking about sort of the healing work of revitalization, but that's a really good reminder that everybody has a role to play. And I think in the context of what's happening in the world and capitalism, individuals in our communities feel powerless to do something about that. But when you're engaging with stories, when you're engaging with medicines, when you're engaging with traditions, when you're engaging in our culture, resisting that destruction that we see around us, and it's laying the framework for how to move forward in a healthier way, and not only our own healing, but the healing of the planet. And there's an incredible amount of power in that. I've been really inspired by this conversation. I hope the listeners are also inspired. I'm, feeling like energized to sort of be in community and sort of have more conversations about how we can be, engaging in storytelling as an act of moving in the direction of self-determination, self-government. It's getting us further down the road. We're chipping at eating an elephant or eating a whale by telling stories and making sure our children hear those stories. And I just want to say Chimi Gwech for that, because I've been thinking about this for a while. It's been a little bit on the back burner, and sometimes I feel overwhelmed about, what the ambition is and how do we actually get there. But, you've given me so much optimism, not only within sort of like the legal frameworks within Canada, but then also like these are tangible things that each and every one of us can be doing and participating in our own communities in order to move the work forward. So Chimi Gwech to you. And I just want to give you one last moment to say anything that comes to mind that you might want to share before we sign off today.
Sure. I think just that on that last point, I think bringing in our youth and our young people into this conversation is so important. And I think RFNG has done a lot. Like, they have a youth group and they do a lot of work, but I think bringing our youth into seeing the power in this work and the role that they can play in it, I think is like so important, because I think like right now it is dark times, and I think sometimes our youth, really, I mean, all the youth I see, even non-Indigenous youth, like are feeling just the weight of like this moment. And so I think in our youth especially, and you talked about sometimes the feeling of powerlessness, I think we sometimes our community members can have in terms of, all the things that are sort of piled on us. So anyway, all I can say is like, as much as that work that is happening, involve the youth, because I think that they're really key in moving this forward. And so yeah, I'll leave it there. Alalin.
Miigwech to Naomi Metallic for sharing your informed voice. We hope you join us next time on Inherent Rights, Informed Voices, Reclaiming Our Rights and Ourselves. Next episode, get ready for an in-depth conversation on Canada's changing policy landscape, where host Dwayne Nishikawa will guide us through the impacts Indigenous peoples have had on policy and how traditional policy benefits First Nations.